Now, I know it's stiff competition, but this might be Donald Trump's dumbest suit yet. His lawyers say he's going to sue the Department of Justice for hundreds of millions of dollars for, I guess, being mean to him? Now, I don't think that's going to work, based on the, law. Unless he's elected president again, because he could just order the DOJ to just settle. Yikes. Chaos lawyer and Trump whisperer Liz Dye has more about this stupid lawsuit.
Thanks, Devin. Last week, Donald Trump's lawyer Daniel Epstein announced on Fox Business that the former president is suing the Department of Justice over the Mar-a-Lago raid. Well, kind of. Epstein says that Trump intends to sue and has told the government about his plan. But then again, we're talking about a guy who promised to repeal and replace Obamacare as soon as he got into office, who said he was going to build a wall and Mexico would pay for it, and that Infrastructure Week was always and forever 2 weeks around the corner. Okay, that last one was true, although not quite in the way he meant it. Anyway, the fact that Donald Trump says he's going to sue someone doesn't mean he's actually going to do it. And there are a whole lot of reasons that he might not file this case, but if he wins in November, well, that's another story. The reason that Trump is announcing that he plans to sue rather than just doing it is rooted in the doctrine of sovereign immunity, which came out of the very monarchies Americans were trying to get away from when they founded the country.
Looks like it's going to be a free country.
In essence, the king is not subject to the law, which exists to regulate his subjects, and so he can't be sued or criminally prosecuted. Donald Trump is quite familiar with this doctrine since he just managed to convince 6 Supreme Court justices that he's functionally above the law in the immunity decision. But when you're not playing Calvin ball, sovereign immunity means that you can't sue the government for torts except in limited circumstances when it gives you permission. Enter the Federal Tort Claims Act, aka FTCA, which specifies the circumstances under which the government will waive immunity and let you sue it. But before you march into court, you have to give the government notice. Under 28 U.S. Code Section 2675, an action shall not be instituted upon a claim against the United States unless the claimant shall have first presented the claim to the appropriate federal agency and his claim shall have been finally denied by the agency. So, you have to tell Uncle Sam that you plan to sue him, and then you have to give him a chance to make it right. And then Uncle Sam, or whichever federal agency injured you, has 6 months to accept or deny your claim. And if they just ignore you, the claim is what they call deemed denied. And then you can go ahead and file your lawsuit. There's a 2-year statute of limitations on these claims, and since the raid on Mar-a-Lago took place on August 8, 2022, the clock was ticking, which is why Trump really did file notice last week just under the wire. So now, the Department of Justice has until approximately February 10th, 2025 to say whether it will fork over the $100 million Trump claims to be owed. Although, of course, Attorney General Merrick Garland could call his bluff and tell Trump to take a hike tomorrow. Daniel Epstein, Trump's lawyer for this very real lawsuit against the Department of Justice, served as a special assistant in the Trump White House. Trump tried to nominate him to the federal bench in 2019 and also to chair a government advisory board in 2020. The Senate ignored both nominations, and Epstein went on to serve as vice president of America First Legal, the conservative law firm founded by Trump's chief xenophobia czar, Stephen Miller. Miller is the one who came up with the idea to separate immigrant children from their parents with no plan to ensure how they'd ever get reunited. Since they left the White House, Miller and Epstein set up America First Legal to represent Americans who have been, quote, victimized by woke politics under the Orwellian guise of diversity, equity, and inclusion. We don't know if Trump wants to sue the government for excessive woke, since Counselor Epstein has not seen fit to publicly release the memo he sent to the Department of Justice explaining why his client is entitled to $100 million. So all we have to go on is quotes from journalists who've been given an embargoed copy of the document. But according to media reports, Trump wants to sue the government for illegally executing the search warrant at his Florida social club Mar-a-Lago in August of 2022. Remember, this is the warrant which Magistrate Judge Bruce Reinhart signed after the FBI presented him with probable cause that they would find evidence of 3 very specific crimes: willful retention of national defense information, concealment or removal of government records, and obstruction of a federal investigation, which they did. The raid turned up over 100 classified documents, despite the fact that Trump's lawyer had signed an attestation saying that the property had been searched and there were no more documents with classified markings on the premises. Similarly, Trump claims that the stolen documents indictment is also illegal, despite the fact that it was sworn by a grand jury after the Justice Department presented evidence that he had retained those documents and refused to give them back in response to a subpoena. Epstein explained to Fox Business that the entire investigation was nothing more than an effort to stop Trump from becoming president again.
We have a word for that gets thrown around a lot, but in this case is very accurate and precise: election interference. And that's what President Trump believes the entire special counsel investigation was about: interfering with his ability to get elected.
And that's all the airtime Epstein got for his big media hit, probably because he's not the most convincing messenger on earth if you're trying to persuade the audience that this is a real lawsuit and not a performative stunt. Trump wants to sue the government for tortious acts against the president that are rooted in intrusion upon seclusion, malicious prosecution, and abusive process resulting from the August 8, 2022 raid of his and his family's home at Mar-a-Lago in Palm Beach, Florida. Intrusion upon seclusion is a Florida state tort that involves physical or electronic intrusion into someone's private space in a way that would be highly offensive to a reasonable person, like, say, setting up a hidden camera that records in your neighbor's bedroom.
Oh my God.
What?
Game changer. Archie got hot. He's got abs now.
It is most definitely not applicable with respect to a federal warrant. And malicious prosecution and abusive process are federal claims which are almost impossible to prove. Trump would have to demonstrate gross misconduct by the FBI and the special counsel, not just point to the Supreme Court's immunity ruling and the dismissal by Judge Cannon and claim that, ipso facto, the prosecution was illegal. And yet, that's exactly what Epstein does. He writes, given the Supreme Court's immunity decision and Judge Cannon's dismissal of the prosecution on grounds that the special counsel's appointment violated the Appointments Clause and his office was funded through an improper appropriation, there was no constitutional basis for the search or the subsequent indictment. That's a reference to Judge Eileen Cannon's ruling that the special counsel's funding structure is illegal, and thus everything he did doesn't count. To be clear, we have had special counsels in various forms in this country for decades. Judge Cannon is the only judge to have ever ruled that a special counsel's appointment is invalid. The dismissal order is on appeal to the 11th Circuit, which already slapped down Judge Cannon once in this case. And not for nothing, but the Supreme Court's immunity decision protects acts undertaken when Trump was president. The documents case is about him storing national defense information in his shower after leaving office and then refusing to return it in response to a subpoena. But honestly, that's the least of the issues with this claim. Let's start with problem number one, the Justice Manual. Epstein told Fox Business that Garland and Wray should have never approved a raid and subsequent indictment of President Trump because the well-established protocol with former U.S. presidents is to use non-enforcement means to obtain records of the United States. But notwithstanding the fact that the raid should never have occurred, Garland and Wray should have ensured their agents sought consent from President Trump, notified his lawyers, and sought cooperation. The National Archives tried for a full year to persuade Trump to simply give back the government property he'd swiped on the way out of the White House. And then, when that didn't work, the Justice Department went to a grand jury and got a subpoena, which Trump ignored. There is no protocol for the Justice Department to deal with former presidents who ignore non-enforcement methods because no other former president has pocketed hundreds of government documents and refused to give them back. But Epstein didn't invent this protocol argument.
Now, obviously, if you're going to sue the DOJ for investigating your crimes, you'll need a terrible lawyer. But if you want a great lawyer, my law firm, the Eagle Team, can help. If you've gotten in a car or trucking accident, suffered a data breach, especially if you got one of those data breach letters saying your social security number has been leaked, or dealing with a workers' comp or social security issue, we can represent you or help find you the right attorney. So just click on the link in the description or call the phone number on screen for a free consultation with my team. Because you don't just need a legal team, you need the Eagle Team. So click below.
For years, Trump and his supporters pointed to internal debates at the FBI in the lead up to the raid on Mar-a-Lago as evidence that there was something improper about executing a subpoena on a former president. The House Judiciary Committee, led by Representative Jim Jordan, deposed Stephen D'Antuono, the former assistant director at the FBI's Washington field office. D'Antuono said that he would have preferred to seek Trump's permission to search his property rather than executing a non-consensual warrant. Jordan even sent a nasty letter to Attorney General Merrick Garland before the indictment dropped, affecting to have grave concerns that your reported actions are nothing more than a politically motivated prosecution. This putative concern was based on D'Antuono's testimony back in June of 2023, when he said that it would have been better to try to get Trump to agree to a search of the premises. He said consent would be good. It would be the best thing for all parties, for the FBI, for former President Trump, and for the country. The best case scenario would have been consent. But D'Antuono was clear that even though he disagreed with it, nothing about the raid on Mar-a-Lago was against policy or against the law. He also called the search warrant completely lawful, insisted that we had probable cause in order to do the search warrant, right? We really did. In hours of testimony, Jordan was never able to persuade D'Antuono to say that the search violated protocol, much less any statute. But even if the search warrant had violated Justice Department policy, that could never give rise to a private right of action because, in plain English, you can't sue the DOJ for violating its own internal guidelines. In fact, the Justice Department lays out all its agency protocols in a comprehensive document called, conveniently enough, the Justice Manual. And on the very first page, it says, the Justice Manual provides internal DOJ guidance. It is not intended to, does not, and may not be relied upon to create any rights, substantive or procedural, enforceable at law by any party in any matter, civil or criminal. So when Epstein says, you have clear evidence that the FBI failed to follow protocols, and the failure to follow protocols shows that there was an improper purpose, he's just wrong as a matter of law. But even if he was right, it wouldn't give rise to a private cause of action, which brings us to problem number 2, the Federal Tort Claims Act. So remember when we said that the government has sovereign immunity and you can't sue it unless it waives that immunity? Well, here's what you can sue the government for under the FTCA. If you've suffered money damages, you can sue for injury to or loss of property or personal injury or death caused by a federal employee's negligent or wrongful act or omission while acting within the scope of his or her office or employment. Essentially, Congress passed the FTCA so that if the mailman sideswipes your car, you can sue for your injuries and get that rear quarter panel replaced. Now here's some stuff you cannot sue for. Assault, battery, false imprisonment, false arrest, malicious prosecution, abuse of process, libel, slander, misrepresentation, etc. So this suit for malicious prosecution and abuse of process is explicitly barred under the Federal Tort Claims Act. And that's why the form Epstein filled out for Trump refers to the day and date of the accident and the nature and extent of damage or the injury and cause of death, because the FTCA explicitly does not cover the kind of claim Trump is making here. And while we're on the subject of actual laws, Epstein claims that the malicious prosecution and abusive process caused President Trump to incur, upon information and belief, $15 million in actual harm due to his legal costs. Those are what you call compensatory damages. That is, they compensate you for money you're out of pocket because of the injurious conduct. In reality, Trump doesn't pay his own legal bills. The money for his legal defense comes from donors to his political action committee, who shelled out $59 million last year alone for legal expenses for Trump and his friends. So even if this were a real lawsuit, Trump probably couldn't recover that money anyway because he wasn't the one who paid it. But wait, there's more, because Trump's goofball lawyer says that he's going to demand $100 million in punitive damages. That's money not just to make you whole for the tortious injury, but to punish the defendant and make sure he never does it again. And that is just not a thing under the FTCA. 28 U.S. Code Section 2674 says the United States shall be liable in the same manner and to the same extent as a private individual under like circumstances, but shall not be liable for interest prior to judgment or for punitive damages. When you file a lawsuit, you have to go through discovery. You have to turn over your communications. You have to sit for depositions. You have to let your employees sit for depositions. You have to call witnesses. You have to make your case in court. All of which is exactly what Donald Trump has been trying to avoid for years now. He went all the way to the Supreme Court to ensure that no one could ever question him in court about what he did in the White House. He sued the Justice Department to challenge the search warrant in a failed effort to claw back all that evidence against him, and he dispatched a whole bunch of surrogates to claim that he declassified all those documents with the power of his mind and secretly turned them into personal records. And thanks to the Supreme Court's immunity decision in the election interference case, if the stolen documents case ever does go to trial, Trump can probably block testimony by his aides about his handling of classified documents at the White House and how those boxes of national defense secrets wound up in his pool shed. But he's not going to be able to claim that as a defense if he himself sues the government and demands $100 million. So if Trump is actually stupid enough to bring this case, he'll have to answer all those questions he's been ducking for 3 straight years, which is a long way of saying this case will never, not ever, wind up in front of a jury. So what's the purpose of this exercise? Well, Donald Trump doesn't always have the best judgment when it comes to filing lawsuits. This is the guy who sued Hillary Clinton, James Comey, and half of D.C. for doing a RICO to him in the Russia investigation. Trump and his lawyer Alina Habba got sanctioned in that one to the tune of $1 million. That appeal is still pending, but in his sanctions order, Judge Donald Middlebrook cited, quote, a continuing pattern of misuse of the courts by Mr. Trump and his lawyers, which undermines the rule of law, portrays judges as partisans, and diverts resources from those who have suffered actual legal harm. He also dinged Trump for his habit of filing garbage lawsuits and then turning around and using them as fundraising vehicles. So it would not be out of character for Trump to file a doomed lawsuit and then immediately fundraise off it, only to quietly drop it later. He did that when he sued Michael Cohen in 2023, pulling the plug on the eve of his scheduled deposition. The most likely plan here is for Trump to enjoy the fun news cycle, which got Daniel Epstein some airtime, and allowed Team Trump to pretend to be standing up to the Biden DOJ. And then, if Trump loses in November, we'll never hear anything about this misbegotten plan again. But if he wins, then Trump can file his claim and simply order the Justice Department to pay it. He can tell whatever obsequious crony replaces Attorney General Garland to cut him a check for $100 million. And it won't matter that it's wildly illegal, because thanks to the Supreme Court, a president enjoys absolute immunity for official acts. He could make the number 200 million or $1 billion, and there would be nothing anybody could do about it, which would be a convenient thing for a guy who may suddenly find himself short of cash.
Now, if you're worried about this outright potential kleptocracy and grift, the solution is to make sure that everyone votes, which you can do with today's sponsor, Tab for Democracy, without even needing to get up from your couch. Tab for Democracy is a team effort between Vote America and Tab for a Cause to harness your internet surfing for a good cause. It's easy to use and you can download it in less than 30 seconds. Here's how it works. Every time you open a new tab, there will be a few ads in the corner of your new tab page. These ads generate revenue that funds Vote for America's charitable impact. And the best part? It's completely free. Currently, less than 50% of people younger than 30 vote in presidential elections. As a result, the electorate, and by extension the representation in government, is skewed towards the older and wealthier. To change that, we need to help get the young people the information and resources they need to vote. Your tabs will support Vote America's effort to make sure every eligible American has their voice heard in our democracy by removing barriers to voting. The end result is a larger, more diverse electorate, one that's better prepared to hold lawmakers accountable. So if you want to save democracy one tab at a time, click on the link below. It doesn't cost you a thing, and it makes a difference. So click on the link below. And then after that, click on this link over here for more Legal Eagle, or I'll see you in court.